Okay, right. I think we've got quite a few people now that have joined us. Thank you very much. So we'll kick off. Good afternoon, everyone, and a very warm welcome to this webinar, which is called Getting to Grips with Marketing and Data Protection. For any first timers to the Data Protection Network, we're a UK-based data protection consultancy. We work with a wide range of organisations, large and small, across a wide range of sectors. We also run bespoke training workshops, and you'll find lots of very practical guidance for businesses that's on our website, which is dpnetwork.org.uk. So my name's Simon Blanchard. I'm a partner at DPN Associates. Prior to working in data protection, I held senior marketing roles in the publishing sector. So I'd now like to introduce our chair today, who is Robert Bond. Robert's a well-respected privacy lawyer at Privacy Partnership Law, and he's also the newly appointed Industry Commissioner at the Data and Marketing Commission. So over to you, Robert, to introduce our panel.
Thank you very much, Simon, and thank you for having me to chair today. Our other two panelists are Julia Porter, who is a partner at the Data Protection Network and was a past chairperson of the Data and Marketing Association, and Chris Combermall, who is the current CEO of the Data and Marketing Association. So we've got a great bunch of people to answer your questions, and I guess we'll just go straight into it, shall we, Simon?
Great. Yeah, I'm just going to do a quick introduction for everyone to the topic that we're talking about, obviously around marketing and data protection today. So it's a very short one, really. So first of all, just to define what we mean by direct marketing here. So it's defined as the communication by whatever means of any advertising or marketing material which is directed to particular individuals. And that's the key thing. It's only where it's directed at specific individuals. And this is the definition that applies to the privacy regulations that we have in the UK, the Privacy and Electronic Communication Regulations, Pekka, which I think we're going to focus on GDPR and Pekka and how those impact on marketing today. So as we said, under UK GDPR and Pekka, we need to remember, of course, that both of these apply from the point of view of when we're handling personal data for marketing purposes. We need to make sure that all that we do is lawful and fair. So therefore, we need to identify a lawful basis for our marketing, which of course it could be consent or it could be legitimate interests. We need to also remember that we have to act transparently and within the reasonable expectations of the individuals that we're looking to market to. And I think it's also just worth mentioning that obviously the ICO produced guidance on direct marketing, as you can see the image on the screen here. This is the latest guidance actually that was just published this Monday. So there is some information there if you want to take a look at the ICO's latest guidance on there. So today we're going to focus more on the electronic marketing side, which is regulated under Pekka, so the Privacy and Electronic Communications Regulations. But it's important to remember that if you're a global business or a business that's marketing across many different territories, that there are other rules that you need to consider. We do have different e-privacy rules in other countries as well. But for the purposes of today, we're going to focus on the UK and on Pekka. And Pekka actually gives us the rules for electronic marketing. So that includes emails, so email marketing, marketing via text messages, also for in-app, any messages that are sent via apps that include marketing content, private messages also via social media, so things like social media advertising and more. So quite wide ranging from that regard. And it also, of course, gives us the rules for telemarketing. If we want to conduct telemarketing as well from the organisation. And importantly, it also covers cookies and similar technology that we might use to track individuals or to target marketing to individuals. But actually, the rules under Pekka for cookies and the similar technology do apply quite widely, so they apply regardless of whether we're using personal data or not. Important to remember that sometimes we do require consent under Pekka, so we'll talk about when we do need consent and when we can use legitimate interests. And also to remember that not all kinds of messages are included within the scope of the regulations. There are carve-outs really for what we call solicited messages and service messages, which are not within the scope of Pekka, but we have to be quite careful with those messages that we don't cross the line and stray into marketing. So I think one of the topics that we're going to talk about today will be, okay, so where is that line? Where does a service message or a solicited message potentially fall into the marketing arena? And of course, to remember that if you're marketing to businesses, to contacts that are in organisations rather than to private individuals, we do enjoy more flexibility. So there's a lot more flexibility for marketing to businesses. Okay, I'm going to stop the slides here, and I'm going to hand back to Robert to start the panel discussion. Thank you.
Thanks, Simon. And I think we've got lots of questions, and the first ones we're going to look at are around Pekka and the lawful basis for marketing. So I'm going to start with Julia. And just, Julia, the question we've got is, in what situations does Pekka require organisations to seek consent for marketing?
Thanks, Robert. So I guess, first of all, divide yourselves up into business to consumer and business to business. And anyone in a business consumer environment has to be much more mindful about seeking consent, but also in a B2B environment, if you're a sole trader or a partnership, you also technically require consent, but there's sort of blurred lines around that. And then the next point really is around broadly, if you are looking to use cookies or if you are looking to send emails, then in most instances, you'd also require consent in that B2C environment. The only major exception to that would be the soft opt-in, which we will talk about in a minute, which is the situation where someone is purchasing something, and if you are buying similar or you're marketing similar goods or products, then you can offer them the opt-out. So my example on that is I buy a dress from Jigsaw, and then Jigsaw might send me an email about a matching handbag or something like that. So in that situation, the soft opt-in would be appropriate. Okay, and Simon, what is valid consent? What does it look like?
Yeah, so that's something we need to be careful of. So in terms of making sure that the consent that we gather is valid, first of all, it must be freely given by the individual. It shouldn't be tied into other kind of terms and conditions, for example, or other things that we're offering. The organisation that is wanting to use the data for marketing must be named. That's, again, the key thing, which is one of the challenges when receiving data from other organisations. It should be an affirmative opt-in. So that means that, again, we shouldn't have pre-tick boxes. We should be asking individuals to check a box or to confirm by saying yes or some other kind of affirmative action. We should also provide kind of granular options, they say, for consent. So, for example, the way that many organisations would do that would be to have separate opt-ins, maybe for email or for telemarketing or for direct mail post, for example, or it might be for different kinds of marketing services. If you say have a newsletter and then offer different kinds of marketing, things like that. So think about how you might break that down. We need to also keep a record of our consent. It's a requirement to keep a record of what consent was gathered and how that was gathered, etc., which for most organisations would do that via the systems that they have, just keeping a date stamp, for example, time and date, and what was the nature of that consent that they gathered via the system. And quite important, I think, is the fact that you must be able to withdraw the consent as easily as you are to give that consent. And it's important, obviously, you've got that opportunity, when the data's gathered.
Okay, and sorry, I was just going to say I can see loads of other questions coming in, so I was just going to move on. Say back to Julia. So can you tell me more about how soft-in works, and are there any limitations to soft opt-in?
So essentially, the soft opt-in works in a situation where you are purchasing or are in negotiation to purchase a product or service. It's generally online, so it could be it's often an e-commerce site, could be a bookshop, could be a kind of fashion retailer. And in that context, then, if you are offering similar products or services to that individual, then you are allowed to offer them the option to opt out. So you imagine you complete your sale, you put in your email address, and there'll be a box there saying, if you don't want to hear from us, tick the box here. So it's different to consent. The challenge with the soft opt-in is knowing the scope. So let's imagine I buy a dress from my fashion retailer, and my fashion retailer happens to have an events business as well. Then you would probably say that, yes, you can hear from them about fashion, but you may not necessarily want to hear about events because you haven't been aware of that in advance. Or you may have situations where you buy something to do with fashion and then you get offered insurance, which is completely separate. And so defining the scope and making sure that it is within the reasonable expectations of the individual that you'd hear about those items is very important. Lots of people will stretch that as far as they can. So I find lots of clients have quite a long debate about, is the soft opt-in valid or not? And so you do have to, I think, risk assess some of these activities to decide whether you think you've been reasonable enough about it.
And I know this is of great interest to Chris and the DMA, so I'm going to switch to legitimate interest, because it isn't all about consent, is my understanding. So can you tell us, Chris, how can a marketer use legitimate interest legitimately for marketing?
Right. Thank you, Robert. And yeah, so we're going to have to go a little bit wider than PECR to answer the question, because PECR doesn't cover the 6 lawful bases for data processing. That's found in GDPR, where you would find the notion of legitimate interest in PECR is that soft opt-in that Julia mentioned. So in GDPR, there are 6 bases of processing data, and they are all equal. So in GDPR, legitimate interests and consent have an equal standing. And that's quite important for marketers, because legitimate interest is identified as a controller is able to pursue its own legitimate interests, and just has to make sure that there are 2 further caveats, that the processing that you're planning to do is necessary to pursue that legitimate interest, and that you conduct a balancing test. And the limitation on when you can use it is only when the legislation specifies consent. So GDPR specifies consent for special categories of data, sensitive data, and PECR specifies consent for a number of channels on communication, but that just covers the sending of the actual message. So when Julia was just talking about, and Simon, consent under PECR, that's consent for sending the message, and you do not need to use that basis for all the other processing that arrives at that. So I'm going to take a slight detour, if you can give me a few extra minutes, Robert, to explain European Court of Justice rulings and the recitals in GDPR, in both EU GDPR and UK GDPR. There is a recital 4, which states that privacy is a fundamental right and not an absolute right, and it must be balanced against other rights, including, specifically written, the right to conduct a business. And I think we can all accept as marketers, you don't have a business unless you can find and keep your customers. That's the essential fundamental activity that every business must have in order to survive. So marketing is implicitly contained as a legitimate interest, advertising and marketing in that. Further, recital 47 states explicitly that direct marketing may be a legitimate interest. So our advice at the DMA is you can and should use legitimate interests for all your marketing activity, including profiling, including postal advertising mail, including telemarketing or customer communications to your existing customers by any means, except where the legislation specifically requires you not to. And where we find justification for that interpretation is in European Court of Justice rulings that cover data protection, because the concept of legitimate interest has existed in data protection for about 50 years. It certainly was contained in the 1995-1998 legislation. And in every instance that a case has gone to the European Court of Justice, they had ruled that there is no limitation on legitimate interest provided the activity is lawful, i.e. it's legal. And further, they have ruled over and over again when DPAs or other national governments have tried to limit the scope of legitimate interest, they have ruled over and over again that no national entity within the EU can limit the scope of legitimate interests. And we see that in some cases, particularly like the Fashion ID ruling, where Advocate General Bobek specifically wrote that advertising and marketing can be a legitimate interest. And again, every time advertising and marketing has risen to that level, the European Court of Justice has backed legitimate interest as a lawful basis for marketing. Now, as I said, there are some caveats. There are parts of the legislation that require consent, in which case you have to use consent. And you do have to conduct a balancing test to ensure that what you're proposing to do does not impact negatively on the individuals. So it has to be fair and proportionate. But apart from that, you can specify your legitimate interest, for instance, finding new customers for my business, and then conduct your balancing test to see if the activity you want to do. And in order to do that, you have to conduct some profiling. You have to understand your customers. You have to understand what products and services might be relevant to them. As Julia said, you need to understand what they might reasonably expect for you. So if your relationship with a customer is based on fashion, they're not going to expect you to send them insurance necessarily. So as long as you conduct that balancing test in a fair and objective way, and the outcome says that your interests and the individual's interests are in reasonably fair proportion, then you can use legitimate interest for most of your marketing activity. And we think that's important because consent is so narrowly defined and requires consent for each specific activity that you could bombard the customer with consent requests for activities that they won't even know what you're talking about. Anyway, I'll stop there.
No. And so I'm going to ask Simon a follow-up, because we've had a number of questions coming in, Chris, as you've been talking. And the message I think I'm getting from you is that if you can use legitimate interest, I would use it, but you need to be accountable. So you've got to do the balancing test. And there's a couple of things here, Simon, that are sort of the overlap. And the one is, if we started with consent, can we now switch with a existing customer to legitimate interest? And what do we do when you look at legitimate interest? It's for the controller and a third party, using the technical definition. So does that allow you to do viral marketing or refer a friend, or is this take it too far, Simon?
Yeah, so let's look at the first one. So can we switch between one basis and another? Well, no, unfortunately, we can't do that. We can't, for example, put a consent statement in front of an individual and say, we'd like you to opt in to this kind of marketing. And then, of course, if they don't give us the consent, we then merrily use it with legitimate interests, because obviously we've given them a right to say yes or no, and they've chosen not to. So we're not permitted to switch the lawful basis to that same individual. So obviously, from the point of view, I guess, from a legitimate interest, we may have a legitimate interest and then choose to upgrade it to a consent and invite people to opt in. That's a reasonable upgrade path if you think of it that way. But no, wouldn't want to do it backwards, where from consent back to legitimate interest. That's
Simon's just there. You're back again, Simon. You're just frozen.
Oh, sorry. Yeah, I was just asking you.
I was going to add an example, actually, is that in a situation, and a charity who has a shop is a good example, where they may have consent for marketing, but if they've got a shop where they've bought some stuff online, you might then use legitimate interest just for that retail part of their business. I think quite a lot of charities will rely on that.
Yeah, and actually
Sorry, to build on your point, Julia, you could use legitimate interest for aspects of the processing that take place up until the point of send. So if you're doing some data hygiene work, if you're looking up against bereavement files, if you're looking up against the telephone preference service or the mailing preference services, even if you're doing the profiling and data enrichment that will help you understand your customers better, you can use legitimate interests, and probably should, because I don't think it's very nice to ask the customer, can I have your permission to look up and see if you're dead or not? I think that's really not something that you want to choose consent for. So we believe, again, strongly, so much of the processing happens in the background that all those activities, which generally is good for the consumer anyway, that you don't send a message to someone who's recently passed away. The families get very upset, and I wasn't meaning to be flippant about it.
But so there's another interesting one came in about schools. So every now and then the school wants to provide information to the parents, sometimes telling them about a charity day or the ability to rent rooms at the school or for rooms being let out. Does that need separate consent? And I think this is personally, as the lawyer, this is a classic example where, from a GDPR point of view, this is a risk-based opportunity. And if you carry out an assessment and you think, to be honest, we're doing nothing bad with the parents' data, we're actually giving them some additional information, and provided that we allow them to object if they so wish, I think legitimate interest is one which applies. Now, we've had some questions, Chris, about what might be changing in terms of soft opt-ins for charities. And I know you're working with the government on the new Data Protection and Digital Information Bill, and also on a GDPR Code of Conduct. Where do you think things are likely to go for the UK with charities and not-for-profits and soft opt-in and so on?
I think you're on mute, Chris.
Okay, sorry about that. Yeah, that's a very good question, Robert. I think DPDI, which is UK's adaptation or evolution of data protection post-Brexit, has consulted widely with the business community, and the DMA, we ran roundtables with the DCMS officials and had a chance to bring forward key issues that affect our community. And given that we have over 200 charities in membership, the limitation on their use of soft opt-in, which gave them competitive disadvantage, if you will, compared to commercial organizations, was a critical issue for us. And as the text stands at the moment, which should be tabled in Parliament in the upcoming couple of months, it specifically extends the soft opt-in for email to include non-commercial organizations, all non-commercial organizations, which means when you're fundraising from donors, you have exactly the same basis to deal with your loyal donors. And as Julia explained, you can use the soft opt-in when there's a reasonable expectation that it's similar products and service. So if you've donated money to a charity, it's reasonable to expect the charity to ask you to donate again, or to tell you about events they might be having around the interest of that charity, or maybe ask you to volunteer to support that charity. All of those things should be completely normal and appropriate within the context of that relationship. So that's really good news. We are working on a GDPR Code of Conduct. I think it's been widely missed that GDPR in Article 40 specifies that it's the role of industry associations or groups of controllers to specify how the legislation applies for their particular sector. So it falls to us as the DMA to define how GDPR should be applied to the processing in our sector. And we've been through 2 rounds of revision with the ICO and have another set of feedback coming. But it's fair to say that our GDPR code of conduct reflects the approach to legitimate interests that I've articulated earlier in the call. And when that's approved, and when our Data and Marketing Commission is approved as the independent monitoring authority, then the independent monitoring body, rather, which you'll sit on, Robert, when that happens, then the ICO will delegate complaints about companies that who have passed a compliance assessment and been accepted as being compliant with that code of conduct. Complaints about their marketing will be adjudicated and investigated by the Data and Marketing Commission rather than by the ICO themselves. But the key thing is the compliance assessment will be robust, because obviously if you get a seal of approval that you can use facing your customers, whether you're B2B or B2C, that has huge value to the companies in terms of reinforcing trust with the consumer environment, that that company is deemed to be a good actor in terms of their collection and processing of data for direct marketing, which, as you saw in the definition, is quite a wide definition that will pick up a large number of activities. But to be clear, in our code of conduct, we specifically do not cover online advertising and real-time bidding, but we cover just about everything else.
So just on that, Julia, I got a question from another Julia. Is there a legal definition of advertising? For example, if the product is free and you have a regulatory requirement to promote it, is this advertising, and is it within the scope of direct marketing?
Wow.
Sorry.
That's a good question. I mean, I think it probably depends. It doesn't necessarily have to have a price. You may, though, be in an organisation where you're promoting a flu vaccine, say, or a COVID vaccine. And I know there was quite a lot of debate about whether promoting flu vaccines was deemed to be marketing or not. And I think in the end, it was considered not to be marketing, and actually they had good reason to promote it. So I think you know, if you're in that situation, you've got to think about what the lawful basis might be if it wasn't consent, and what the reason is and what's in it for the customer. Because I don't think, I'm not aware, I mean, I come from an advertising background, I'm not aware of a legal definition of advertising in this context. I think the only definition we've got is the direct marketing definition that Simon mentioned at the beginning of this webinar. Okay.
I wanted to move on because of time, because we've got a number of questions around when is marketing and when is it a service message. So Simon, where's the distinction between solicited and service messages and direct marketing?
Yeah, I think that's a good point. So first of all, let's just outline what a solicited message would be. So this is where an individual has raised an inquiry with you and wants you to provide some information or to provide something via email, or to contact them. So they said, I'd like can you send me this, for example. So you're obviously perfectly within your rights to be able to respond to that. That would not be classed as marketing. That would be a solicited message. And therefore you can respond to it. Obviously, you can't go too far with that. You can't suddenly then take that individual and then look to, assuming this is a consumer rather than a business, just to be clear, from a consumer point of view, suddenly you wouldn't want to then add them to your marketing list, suddenly raised an inquiry, because then you might be then sending additional marketing to them that was unsolicited. So we just need to be clear, it's a solicited message because they've said, I'd like this, can you send it to me? The next one, let's look now at service messages. So service messages are messages that are sent to fulfill a particular product or particular service, really, that you have a contract or an agreement with a customer to provide. So this might be, for example, an order acknowledgement. It could be a confirmation of a payment or a direct debit. It could be providing certain information that's required by law, because again, many sectors that we work in will have specific legal requirements. Take financial services, for example, there's specific information you have to provide by law. Or it might be, just delivery of your goods. I bought some shoes online. Your goods will be, your shoes will be delivered next Tuesday, for example. or the dress that Julia was talking about, for example. So those kind of things which provide that purely factual information would be service messages. But the situations that we need to think about, I guess, are where there's a commercial pressure there, whereby the organisation might think, oh, let's just try and cross-sell something on that, or let's try and upsell them, and wish to, to add a message on there that says, a bit like the examples we talked about, that might want to say, well, why don't we offer an insurance, or why don't we add something to it? We just have to be careful, really, there that we don't. That would turn it into a marketing message, effectively, from a service message into a marketing message, and those are the ones that we need to take care of. And particularly, there've been kind of some fines in this area, whereby organisations understood how far that service element can go, and have strayed into the realm of effectively including kind of upsell, cross-sell marketing messages within those service messages. So those are the areas I think we need to be quite careful about.
Okay, there's a couple of questions come in around, sorry to go backwards, but on whether public authorities can rely on legitimate interests. And I'm quite happy just to take this one myself for the 2 or 3 people that have asked similar questions. So public authorities or organisations that are acting under a statutory duty can't rely on legitimate interest, but then they would rely on their public task duty to make certain messaging to parents, students, etc. The ICO has made it clear, just to be specific, Penelope and Kathy, that you can use legitimate interest if you are a public authority, but you are offering services outside of your statutory duty. So an example that I would use is, you might be a local authority that runs the public swimming pool, but you decide to set up a commercial gym or a Peloton class, etc., and you are doing a non-statutory duty. You might, because users of the swimming pool would also like to hear about gym facilities, feel that that is a reasonable, legitimate interest that you might rely on. But again, take a risk-based approach, and do the assessments, and be prepared to stand up for the decision you've taken, on an accountable, transparent basis, I think is the message there. I've got a question here about email marketing. My business works with a partner, i.e. third party, to send our promotional content to their email subscriber list. Is this okay? I don't know whether, Chris, you want to start on that one?
Sure, I can take that one. So as I understand it, the partner company is not providing the data directly to your company, and they are then doing what would be called a hosted mailing, using their relationship with their own customers. And that's something, when I was an email practitioner, we did a lot when we had clients like the Telegraph, who never let their data leave their organization to third party. But if you were registered, say, within the gardening newsletter, the Telegraph might say, here's a carefully selected offer from, Parker Seeds, or something like that, that is just for our members. And that's totally legitimate and okay, because the person sending the message, and here's the sending that's important, is the one who has the relationship, and the product and service they're offering is within the context of the relationship and the interest area that that person has. So provided that, and it's hard to answer the question without knowing what are the products and services you're selling, and what are the product and services the third party hosting and sending the emails is. But as long as those two are aligned in the reasonable expectations, that should be okay. And it is then your legitimate interest to work with them, and their whatever lawful basis they have for their relationship with the customer that comes into play.
Okay, so another question is like the complete opposite of that. So it's, we buy in third-party email data for our own marketing What do we need to think about here, Julia?
Well, you need to know what that individual has signed up for. So understanding the provenance of that data and what they've agreed to receive, and most likely consent is going to be the basis on which you would capture that data. And actually, as the person sending out the marketing, you've got to make sure you've got a clear audit trail about, who these people are, where they've come from, and has the supplier of the data carried out a proper due diligence process themselves.
Okay.
Robert, could I just pick up on the hosted email a little bit? Because I just want to add something just on that. Because there is a risk that just organisations need to be aware of, I think, at least in this area. And that's the risk that the organisation that is providing the content into a hosted email, so a third party's email content, will be in many cases regarded as the instigator of that email. And I think that's particularly true, particularly where the organisation is providing all of the content for that newsletter, or providing a complete soulless email through a third party, if that makes sense, rather than is one of the advertising slots on a combined newsletter, I think particularly. But there has been obviously enforcement in action in this area, because the instigator of the email has to comply with the responsibilities under Pekka, the rules under Pekka, as well as the sender of the email. So I just wanted to raise so that people were aware of the case with Saga, for example, and not the only ones that have been picked up on here, but the Saga one's quite an example, and that's where they sent out communications through a third party, through what they regarded as an affiliate partner, who would send emails on their behalf. And in that regard, in that situation, the ICO found them to be the instigator of it, because all of the email was all about Saga and their financial services products and their Saga services, and they were fined, I think it was £150,000 for that, because they said they relied on indirect consent, and the ICO's view on that particular one was the consent was not clear and transparent enough. The individuals were not expecting, it's about the reasonable expectations. Again, it comes back to the same thing, I think, that the expectation of the recipients of those emails were that they were not expecting to receive emails with content that was all about Saga, for example. Okay. So I think it comes back to the same thing, being transparent, making sure you meet the reasonable expectations, but just be aware that there's a risk if you don't do that.
So the next one is around social media marketing, lookalikes, and so on. And I'm going to go to Julia first, but then I'm going to ask Chris to consider how the code of conduct is going to, impact on members and their standards. But we use social media to target advertising to our customers and to lookalikes. And we've also got a couple of questions in about how dangerous is it to start using algorithms and other indicators to make assumptions about people's likes, health, whatever. What do you think of the privacy implications, Julia?
Well, so that's quite a wide question, Robert.
Yeah, well, there's sort of two or three I'm throwing together here.
So I think the first thing is to decide what sort of data you're using in order to do this customer profiling. And when I talk about profiling, I'm very definitely talking about it in the context of marketing activities rather than necessarily data protection. So if you look at, say, Facebook and a number of the other platforms, then you can do kind of direct matching of individuals with emails. And in that context, it's very hard to imagine a situation where you can't ask for consent to do that. But there are all sorts of other ways, means of creating segments and profiles. And so an awful lot of these situations, you can pseudonymize data, create a profile with the tools that people like Facebook provide, which then allows you to identify matches against an against a group of individuals. So there's no kind of direct matching, but actually say, here's a bunch of 2,000 people. We'll say, okay, they look like they're aged 40 to 60, they come from this part of the country, they're mostly female, and then you go and find people like that within the Facebook database universe. And so in that context, actually legitimate interest in terms of providing that kind of profiling and matching feels fair enough. And certainly when I talk to clients about that, I would treat that as a legitimate interest. And then there's other situations where you may actually look at anonymized data. So it's not even pseudonymized, it's anonymized, where you match your individuals against a database of anonymous data, and then you kind of have profiles that you can flag against individuals. So you're not appending data to a profile, but you're actually getting an indication of the type of group that they occupy. And so as a marketing person, so as a marketing director for quite a long time, think about the extent to which you need to actually find out what an individual wants or needs, and whether your targeting can be delivered effectively enough using pseudonymized data. Pseudonymized data is far less risky for a start. And actually an awful lot of the kind of alternatives to using cookies is based on data pools using pseudonymized data. So it's something that's very much worth investigating. The ICO, just a final point, the ICO are developing some good guidance actually around use of pseudonymized versus anonymized data, and that's something that's worth investigating as well.
And then I was saying I was going to ask Chris to comment about how you see those that sign up to the GDPR Code of Conduct. How are you going to measure or help them to be compliant marketers?
Yeah, well, in order to gain the benefit of that co-regulatory system, anyone who wishes to sign up will have to go through a compliance assessment process overseen by the Data and Marketing Commission. That process will be robust to ensure that they meet the obligation in the codes of conduct. So the code of conduct in each chapter has a series of musts that will make you compliant, that are summarized at the end of the chapter. And the compliance assessment process will make sure that companies have correctly implemented that. And then you will be required to do a new assessment every 2 years. But in between, the ICO has been clear that they expect there to be ongoing monitoring to ensure those companies remain compliant, which is critical if the system is going to be trusted through the supply chain and by consumers. So it should be quite good, because marketers, we believe, will wish to avail themselves of that opportunity, because you get a trust mark that you can put on your communication to the general public, to your potential customers and your existing customers, to show that you're a compliant company. But then more importantly, I think, is in the supply chain. So if there happen to be third-party data providers that passed the compliance assessment that said the data they are offering to the market is compliant with GDPR and the basis on which it's collected, and they get a seal that is a signal to brands wishing to buy that data, then of course that has huge commercial value. And if in order to get that seal you need to change your behaviors or ensure that your data matches the requirements, then I think that creates an incentive to build a safer ecosystem that protects the privacy of consumers, because companies will desire those commercial benefits. So I think it's hopefully an ideal virtuous circle. And then consumers can choose brands who have that seal, and we do hope the brands who earn the seal will choose suppliers that earn the seal, so that they can be assured of compliance throughout their supply chain.
Okay, thank you. I wanted to move on to several questions that we've had about the use of profiling tools and trackers, and specifically Google Analytics. We use Google Analytics on our website. I understand some EU regulators have a problem with Google. Do we need to do anything? Should we do anything? Julia.
This is really tricky, actually. So the main problem the regulators have with Google is the fact that the data is exported to the US and stored there, and that in the US you've got surveillance rules which are stricter than there are here. So that's why lots of regulators across Europe are stopping or banning the use of Google Analytics. Having said that, Google Analytics is huge and is used by millions of companies and a lot of small businesses as well, because you can get free setups. So then there's really a risk assessment about how risky is it for me to use Google Analytics to understand performance on my website. I think there's another point to consider is that, are you using Google Analytics simply to measure anonymized data to understand trends of how your website is being used? Or are you linking that to your ad tracking tools and using the information you've gathered on your website in order to do remarketing and ad tracking? So one of those things is very low risk. And actually, I know of a number of very large organizations who include Google Analytics in effectively their essential cookies bucket. But if you're tracking it and linking it to advertising, then probably you need to use consent for that. Then there's a third point, which is that we've got Google Analytics 4, GA4, coming into force in the middle of next year. And everyone who uses Google Analytics now will be getting invitations saying, please switch over. I would suggest you should switch over, not least because you don't want to run out of road when it comes to tracking data, because as soon as you switch over to the new system, you then start building up a body of historical data around how people use your website. But actually, the tools that have been built into GA4 are more privacy friendly than the ones that are in the previous version of Google Analytics. So if you want to minimize your risk, move to GA4, make sure you switch on all the right buttons in order to anonymize, that you have activity that's event-based marketing rather than individual marketing. And then I think you just need to decide in your organization how risky you feel it is to continue with it. I mean, there are other people who provide analytics, so you can certainly look for others, but you know, DPN uses Google Analytics. I think it's a pretty low risk activity.
Yeah.
Can I just in and add something there, Robert, in terms of the future legislation? The drafts that exist at the moment contain further exceptions from consent for cookies and cookies used for purely statistical purposes, which DCMS believes includes audience measurement and analytics, would be exempt from cookies in the new UK legislation. But that doesn't overcome the problem if your organization is doing business across Europe, that there is that EU-US problem on international data transfers that Julia was referring to. And that legislation, of course, still has to pass Parliament and is some ways from being enforced.
Yeah, and I go back again to the risk-based approach. I think it some organizations will say, we don't want to switch, Google works for us, we're low profile, we're low risk, but there will be others that are going to get complaints, and a couple of questions here have come in from organizations where they think they've been doing the right thing, or maybe they've been pushing to the edge of reasonableness, and now they've got an individual who says, you've been using my data without my consent, I don't agree, it's your legitimate interest to do X, Y, and Z. I'm exercising my rights. I want to be erased. I want to know what you've got about me. I guess my advice would be, you should try as much as possible to make the unhappy person happier. But we are seeing quite a lot of aggressive subject act, weaponized subject rights requests. And I don't know whether you're seeing more of this with your members, Chris.
Yeah, so I think the first thing to note, and it's a really important aspect, certainly in GDPR, that the individual has an unfettered right to object to direct marketing at any time, whether it's based on consent or legitimate interest. So if somebody asks you to stop sending them direct marketing, even if you're using legitimate interest, you have to stop. That's a key aspect of legitimate interest, is that if someone asks you to stop, you must stop. And that's the same under consent. There is no difference in that regard. So if somebody wants you to stop, that's fine. There is an increase in vexatious requests, and the new legislation does deal with that and raises some new benchmarks and will exempt companies from having to deal with subject access requests that are vexatious, and you know, it's being finalized in the text, but that is an issue. It will be hopefully one of the issues that the new legislation tackles. But again, I'll emphasize you cannot rely on the new legislation until it's tabled to Parliament and completes its journey, and then eventually comes into law after whatever grace period is built into the legislation. So it's a bit down the road, but it is a known issue. And companies should hopefully have more flexibility in how they deal with it in the future.
So a couple of questions, Simon, for you. And they're around when is, you know, how long, looking backwards, can you use the data for further marketing? So you've got stuff on your system, and you've decided actually we could combine these data sets. We haven't heard from these people. I think we could still send them a message to say, do you realize you're not using your membership benefits or whatever? When is data out of date?
I think that's a good point. So there isn't a specific period that is laid down. I think that's the key thing to make clear. There's nothing that says it must be 12 months, it must be 48 months, or, you know, whatever it might be. The important thing is to work it out based on understanding your market, understanding your audience, and looking at people's reasonable expectations, things like product life cycles, for example. So there'll be certain situations whereby the period by which somebody might expect to receive your marketing communications in certain sectors might be a very short period, might just be 12 months, for example, or maybe in some areas might be even shorter. But in many businesses, it's possible, I think, to justify a situation whereby a slightly longer period might be appropriate. I've, again, had this conversation many times with different clients in different sectors, and some would justify a period of 2 years. Some may feel it's 3 years might be an appropriate period. And again, I think it's something that the organisation needs to work out for themselves. And as we talked about, doing a risk assessment, documenting that, and you can look at factors in terms of, you know, the product life cycle, as I said, but also what's a reasonable response period. So I'd suggest organisations look at what kind of levels of response they've had from older data as well. And the other point, which I imagine Julie will be itching to mention as well, is the fact that also bear in mind that obviously as your data ages, it becomes less effective. Simple as that. So you might not get the ROI on going to older data as well. After a certain period, you're going to find that your responsiveness of your data is going to decrease as well. So you've got to consider both the consent angle and also the fact you're losing accuracy of your data as well. So, you know, people change email addresses, people move house, etc. So data's aging at the same time as people's interests are changing. And at the same time, you know, so the effectiveness of your data at the same time is getting older. So the business should just make a call on this and make a decision and document what their decision is for a period of consent. Again, same for legitimate interest too, and identify an appropriate period with which you'd want to refresh that.
So if you've got customer data, it wouldn't be unreasonable to send messages to them to ask them to confirm that the data you've got is still accurate and up to date.
Exactly.
Is that all right to do that?
Yeah, I think within a reasonable period. I think if it's like 10-year-old data, you might question that. But I think within a reasonable period, you know, so if you decide that your period is 2 years, for example, as you're getting close to the end of that 2 years, drop me a line saying, have we still got this up to date? Is your correct contact details? Do you still want to receive? In fact, I got one just actually a couple of days ago. Would you like to still receive our marketing? If not, let us know. So yeah, that was a legitimate interest-based one. But yeah, I think the key thing is organisations need to work it out based on their own specific circumstances and their own audience. Do you guys agree?
Sorry, if I could just jump in on that too, is because we cover that issue in the GDPR Code of Conduct, which we'll hopefully get approval for. But a key point, just for clarity, and I think it's assumed by what you said, Simon, that we believe the clock resets when someone buys from you or takes a positive action. So the clock isn't 2 years and someone bought from me 10 times in that 2 years and I have to stop communicating to them. We think every time someone buys a product or takes a very strong indication that they're still interested, by clicking a link and coming to your website, that you can start the clock. So I think Simon is really talking about dormant people.
Yeah.
And in the life cycle, obviously, the longest life cycles are things like homes, automobiles, and so on, where it may be reasonable to not expect someone to be in the market for a new car within 2 or 3 years of when they bought one. So there is some flex into it, but the clock resets was the point I was wanting to make.
Yep, I absolutely agree, Chris. Thanks for clarifying that.
And I'm conscious we've got about 3 minutes left, but there's one, Chris. I've got a question about that code of conduct or seal. When do you anticipate that suppliers would be able to subscribe to that? And will there be a register of those that are signed up to the code?
Well, it depends on the approval process itself. So we have another round of feedback from the ICO coming up on December 14th. And the DMC, as the monitoring body, has a round of feedback coming from the ICO on December 20th. Depending how many amendments or how many issues there is conflict, we're really aiming and hopeful of getting something approved, you know, by March, April timeframe, but I can't be more specific. And of course, if there's points where we end up, so far there have not been major policy issues where we've disagreed. A lot of it has been drafting, editing, consistency of language. So their feedback is very meticulous. But for the moment, we don't have major disagreements on policy that would cause a delay. And I think the DMC approval process also is time consuming, labor intensive, and document heavy, but nothing to expect that we wouldn't ultimately arrive at a positive approval. So it's hard to say exactly, but we're pushing hard to make it happen by March, April. And then we would be taking applications that come to the code owner, which would be the DMA. We pass them to the DMC, who conducts the compliance assessment. And if someone passes, they send them back to us to issue the seal of approval. And at that point, complaints about your marketing will be passed by the ICO or submitted directly to the DMC. But it's honestly our true hope that there wouldn't be many. If all the companies that get the seal are generally compliant, we don't believe that the ICO should be getting humongous amounts of complaints about those companies, or something will have gone badly wrong in the system.
Okay, thank you. And I'm going to one last question for you, Simon, and then as I'll leave you to then wrap up. How can you, or should you, incentivize individuals to opt in? How do you manage the value exchange?
Now, I'm going to be completely honest and say I'm not quite sure where we're at with this one, because I know in the past, the concept of incentivizing opt-in was very much frowned upon. But I did see some flexibility in some guidance a while ago. So I don't know, is this, Chris, can I ask, is this something that's been discussed at all within the conversations that you've been in? Because I'd be quite interested if there's any update on that and what the current view is on incentivization.
Well, consent has to be freely given.
Yeah.
And you should consent to receive offers, and you should be clear on the value exchange. So if you get my email marketing, you know, you will from time to time be offered discounts on, and we all know how the loyalty programs work with things like Tesco Club cards, that these days it's magnificent because you get offers for discounts on things that you actually buy rather than things you don't. And so there's an ensuing benefit that I think is absolutely fine. But on the other hand, if you said, I'll give you £10 direct to your bank account if you give me consent to spam you about stuff you don't care about, I wouldn't say that is a legitimate consent. So I think the consent has to be for the relationship with the company. It has to be related to a set of benefits that the company is offering over time. in terms of, say, free subscriptions to content, or it might be, you know, as I said, discounts in your loyalty program. But it can't be, I'll give you £10. And anyway, I don't know why anyone would want to do that. Why you would bribe someone to consent to receiving emails about a company they don't care about and will never buy from you. So it doesn't make too much sense in that context. So, you know, I don't know. Hopefully that's helpful.
Thank you. Simon, probably want to close out now?
Yes, great. So yeah, we're up to the hour. So thanks very much, everybody, for joining us for this. Appreciate everyone that stayed to the end. Thanks very much, Robert. Thank you, Chris, Julia as well for our panel. Enjoyed it, and look forward to seeing you all again on another webinar. Thank you. Bye.
Thank you. Bye-bye.
Bye.